My name is Tom Hardiman. I'm a judge on the Court of Appeals for the Third Circuit with chambers in Pittsburgh, and it's really an honor to be here with such a distinguished group of scholars in the administrative law area, and also one of my colleagues from the federal bench, Judge Kavanaugh, who sits, as you know, on the D.C. Circuit, where I imagine there remains no shortage of ad law cases. But our first speaker this morning is going to be the Honorable Ronald Cass, a 1973 graduate of the University of Chicago Law School. Mr. Cass has been president of Cass & Associates, PC, since 2004. He was formerly the dean of Boston University School of Law from 1990 until 2004, when he became dean emeritus. He served as vice chairman of the United States International Trade Commission during the Reagan and first Bush administrations. He's also the chairman of the Federalist Society Practice Group on Administrative Law and was previously chairman of the Administrative Law section of the American Bar Association, where he served in the House of Delegates. He's the author of more than 100 books and articles, including The Rule of Law in America and Administrative Law, with Colin S. Diver and Jack M. Bierman. Dean Cass began his teaching career in 1983 at the University of Virginia Law School, following a clerkship with Judge Collins Seitz of the Court of Appeals for the Third Circuit. Please welcome Dean Cass.
Thank you very much, Tom, for the gracious introduction. It's a delight to be at the Federalist Society program. I'm going to start with two quick stories that you have to keep in mind for the rest of the talk and possibly for the rest of the program. First involves the film True Grit, not the new one, the real one, and a conversation between a blonde, which is the last group you're allowed to pick on, and a brunette who were going to see the film. And the brunette said to the blonde, I will bet you $50 that in this film, John Wayne falls off his horse. And the blonde said, well, I'll take that bet. So they go see the film, and of course, John Wayne falls off the horse in the film. And at the end of the film, the blonde pays the $50 to the brunette, who says, I can't take your money. I'd seen the film before, and I knew John Wayne would fall off. To which the blonde replied, well, I'd seen the film before too, but I didn't think he'd fall off again. So that's one thing to keep in mind. Second quick story involves twin boys. They go fishing with their grandfather. They come back late at night. They've caught no fish, but their vocabularies have expanded. They come down to breakfast the next day. Mother says to the first Johnny, what would you like for breakfast? He says, I'll have some goddamn son of a bitch effing cornflakes. She smacks him across the face, sends him to his room, says she never wants to hear language like that again, and then turns to his brother and says, Jimmy, what would you like? And he hesitates a moment and says, I'm not sure, but you can bet your sweet ass it won't be cornflakes. So we have two problems we're dealing with today when we talk about the healthcare decision and commerce power. One is the problem of line drawing, and as you can see from the cornflake story, sometimes when things are happening in tandem, people have trouble separating what the real line is between what's right and wrong and what some of the other things are that might be in the way. And the other problem is one of repeat play and trying to see whether things keep happening the same way. The commerce power is not the only significant power to the creation of the administrative state. We have in the federal government right now about 4.5 million employees, about 3 million on the civilian side, and about 1.5 million on the uniformed military side. And a lot of the federal establishment is bottomed on powers like the power to run the Postal Service or the power to create armed forces or the power to operate the Treasury, all of which are predicated on things other than commerce. On the other hand, a great deal of the regulatory state, a great deal of what we do in administrative law and deal with in administrative agencies is predicated quite clearly on the Commerce Clause power. When we look at the Commerce Clause power, this was one of the important powers at the center of the writing of the Constitution. It was important because the states had the wrong incentives in regulating commerce, which back in the 18th century actually meant trade. It did not mean anything having to do with commercial activity or money-making activity. States had the wrong incentives because they could externalize a lot of costs and internalize benefits from their regulation of commerce. And the Articles of Confederation really gave plenary power to the states to do this without much power for the federal government to set things straight. So when the Constitution was written, it was done in a way that gave the federal government authority over the interstate portion of commerce and left the intrastate portion of the state. Well, over time, of course, this eroded as more and more things were swept into the federal power and less was left for the states to do. When we come to the case that was up for decision this past year, the real question was, would we sweep away the last vestige of constraint on what the federal government could do, or would we try to enact a line that was defensible against future encroachments by the federal government over whatever was reserved outside the federal power to the states? A lot of people who were looking at this thought that the line between action and inaction was a difficult one to draw, but it was one that was important to a lot of people because if sitting here today you are engaging in a purchase in the healthcare market because you are self-insuring, there's not much left to the notion that this is a government of limited power. The decision on this matter by the court in an ordinary case would be an interesting one that we could then talk straightforwardly about how it gets implemented and what happens. But here you have a very different sort of decision in a couple of ways. The first way is that you have a decision written for the court that is for one justice and only one justice, because no one else joins that part of the decision. And although the Chief Justice references the decision by 4 dissenting justices, which is unusual because it is written as a decision by 4, not by 1, joined by 3 others. Although the Chief Justice references that decision, the dissent, which is the majority on this part joined with the Chief Justice, the dissent does not mention the Chief Justice's opinion. So you're in the peculiar situation of having 2 different opinions for the court that don't really refer to one another, that say essentially the same thing. Ordinarily, that would be the majority decision, but there will be questions down the road about what sort of weight it gets in this posture. The second problem is that this part of the decision, as Justice Ginsburg and those joining her concurring say, is dictum. And although the Chief Justice responds to that, it's very difficult to see a decision, a part of the decision that is not necessary to the outcome of the case. In fact, it is completely unnecessary to the outcome of the case, which is decided on other grounds. It's very difficult to see that as anything but dictum. So you have a dictum for 1 + 4 justices in a case that is addressing a critical issue and addressing it in very clear way. The 5 justices that speak to this issue and say there is no basis under the Commerce Clause are very clear about why there isn't and why there shouldn't be and why it's important, and the question is what happens to that down the road. When we draw these lines, it's very difficult to cabin the regulatory state which tends to reach out for more and more authority. And we've seen this a number of times. We've seen efforts to put constraints on the government. We saw this under the Constitution with the non-delegation doctrine, which had a brief rise and then a fall and then another sort of rise for a moment and then a fall again. We've had difficulty applying the non-delegation doctrine in a serious way to constrain the outreach of government under statutes. Other Commerce Clause cases, we had efforts in both the 20s and the 30s to use the Commerce Clause to cabin federal power. And after Wickard and Filburn, those efforts sort of vanished and really did not reappear except for one or two cases where they were combined with other constitutional constraints until the healthcare decision this past spring. We also saw it with substantive due process, which had its own rise and fall. And we've seen it in areas like the question of how Congress can actually constrain regulatory power after they've handed it out. The Chadha decision, which said you could not have a one-house veto, is as clear a decision with as bright line a rule as you can get in the constitutional realm. And yet, after that decision was handed down in 1984, Congress passed thousands of statutes that contained one-house vetoes. Now, none of them ever was implemented in a way that could then be challenged again under Chadha. The rule in Chadha was very clear. But the fact that Congress thought it was all right to keep including these provisions in the law is a signal about how much or how easy it is to use constitutional determinations to limit federal power. Also, when we look at what happens in statutory interpretation, often the courts reach out and try to adopt a rule that will constrain federal power. You look at rules like the rule on what sort of jurisdiction an agency has. Over time, agencies tend to discover jurisdiction they didn't know they had before. We saw that in the FCC's cable television rule, where it went to Congress repeatedly for a decade asking for authority, and then discovered after Congress didn't give it authority to regulate cable that it had it all along. We saw this with the FTC, which for 40 years sought authority to adopt rules, to get rulemaking authority from Congress. Congress kept saying no, and then after 40 years, the government discovered that it had it all along. We saw that with the FDA's authority over tobacco, which it had always said it didn't have until one day it discovered that it did have it after all. Now, the courts have periodically, and Judge Kavanaugh's court has recently in the Comcast case, drawn lines to try to bring these things back in. Comcast abandoned or rewrote rules on ancillary jurisdiction over agency outreach to grab things that were not originally within their mandate. But this may be one of those times when the court adopts a decision, draws a bright line, and it's hard to keep going back and drawing that line again because there is so much pressure by the government to keep expanding what it is it can do. Courts have to be willing to engage in this on a repeat play basis. They have to believe that John Wayne will fall off the horse each time, and they also have to be able to draw lines in a way that let people say things other than, you can bet it won't be cornflakes. Thank you.
Thank you, Dean Cass. Our next speaker is Professor Timothy Jost, a 1975 graduate of the University of Chicago Law School. Timothy Jost holds the Robert L. Willett Family Professorship of Law at the Washington and Lee University School of Law. He is co-author of a casebook, Health Law, which is used widely throughout the United States in teaching health law, and of a treatise and hornbook by the same name. Professor Jost has also written numerous articles and book chapters on healthcare regulation and comparative health law and policy, and has lectured on health law topics throughout the world. His most recent book is Healthcare at Risk, a critique of the consumer-driven movement, which was published by Duke University Press in 2007. Professor Jost has a long and storied history, not only teaching healthcare law, but also practicing healthcare law soon after he left law school, and we're privileged to have him with us. Please welcome Professor Jost.
Thank you for inviting me to join this distinguished panel. I must confess to feeling a bit out of place. I'm not a constitutional law scholar. I've never taught administrative law, though I've written about it, and I'm definitely not a Federalist. I am a health lawyer, and for the past 3 years, my work is focused on implementing the Affordable Care Act. I therefore hope to bring to this panel the unique perspective of a health lawyer who supports the Affordable Care Act. The Democratic Party swept both houses of Congress and the presidency in 2008, achieving for a brief time a 60-vote supermajority in the Senate. This gave them the opportunity to finally achieve a goal that progressives had sought for nearly a century and had achieved in every other developed country, which was providing access to health care for all. To achieve this goal, Congress had before it at least 3 alternatives. First, it could have expanded Medicare, a popular national social insurance program funded through payroll taxes, general revenue funds, and private premiums to cover all Americans. This would almost undoubtedly have been constitutional, but it was not politically possible. Even a last-ditch effort to expand Medicare to cover uninsured Americans above age 55 went nowhere. A second possibility was to expand Medicaid, our federal state cooperative program for the poor. Medicaid was created in 1965 as an adjunct to the New Deal public welfare programs, and it has in fact, contrary to the Chief Justice's characterization of the program in the NFIB program case, expanded steadily since the 1960s to cover more categories of the poor. The ACA expanded Medicaid once again, this time to cover all Americans with incomes below 138% of poverty, but expanding Medicaid to cover all of the uninsured was not considered. The solution that Congress in fact settled on was instead to make our private health insurance system work. Although private health insurance is available almost everywhere in the world, the United States has since the 1930s relied to an extent found nowhere else on private health insurance, mostly employment-based, to finance health care. For a time, this worked reasonably well, but since about 1980, there has been a decline in employee coverage, and the non-group market has never really worked. The Affordable Care Act tried to make private health insurance work for everyone by refocusing competition among insurers on price and quality rather than on risk avoidance. It required guaranteed issue and community rating and banned pre-existing conditions clauses beginning in 2014. It made funding available through tax credits to those unable to afford to pay the full cost of insurance premiums. It encouraged large employers to offer health insurance by imposing a freeloader tax on employers who failed to offer adequate, affordable insurance and whose employees ended up getting public subsidies. Finally, it imposed an individual responsibility requirement to encourage Americans who could afford health insurance to do so. This third model was based on ideas that had been proposed by Republicans for years, and over 150 amendments offered by Republican congressmen were added in committee during the summer of 2009, when there was hope that this bill would be bipartisan. By the fall of 2009, however, Republicans in Congress concluded that there was more to be gained from opposing the bill than from working together on it, and in the end it passed with only Democratic votes. Affordable Care Act opponents, having lost in the democratically elected Congress, turned to the courts to achieve their political goals. The NFIB litigation was from the beginning starkly political in nature, brought by Republican governors and attorneys general, sometimes over the opposition of Democratic governors and attorneys general in their own states. It was only one of about 24 cases filed challenging the Affordable Care Act. Most of the lower courts upheld the statute or dismissed the cases on jurisdictional grounds, but the NFIB case eventually got to the Supreme Court, on which the political opponents of the law hung their hopes, as the court had a 5-4 split favoring Republican appointees. In the end, the Supreme Court did little damage to the statute. Although the Chief Justice held that Congress lacked the power to adopt the individual responsibility provision under the Commerce Clause, he upheld the provision as a tax. He made the Medicaid expansion optional rather than mandatory, but otherwise upheld the terms of the expansion. With the re-election of President Obama, it is likely that the implementation of the Affordable Care Act will continue as planned, covering millions of Americans with Medicaid and private health insurance a little over a year from now. The question remains, however, how much damage does the NFIB opinion do to the ability of Congress to address national social and economic problems in the future? It seems to me that the Commerce Clause holding of the case, if it is a holding and not merely dicta, does little or no damage. As the government argued repeatedly in the ACA litigation, health care is unique. It is difficult to think of another situation where Congress would use a purchase mandate imposed on individuals as a means to addressing a social or economic problem. Congress actually never contemplated forcing Americans to eat broccoli. Further, the courts upholding the individual responsibility provision as a tax breaks no new ground either. As the Chief Justice notes, Congress often tries to encourage or discourage private behavior through taxation. I worry about two aspects of the opinion, however. First, the court's Medicaid holding opens up a broad new front for attacking federal-state cooperative programs. Never before had any federal court struck down any federal program based on the coercion doctrine adopted by the Supreme Court. Indeed, both of the cases in which the court had in dicta earlier adverted to the possibility of such a doctrine had noted the impracticality of applying the theory. I expect that we will see repeated challenges to spending clause programs in coming years based on this new coercion doctrine. One reading of the opinion is that the states have a vested interest in the continuance of any cooperative program unchanged, and that any time Congress attempts to impose new or different conditions on participation in a cooperative program, litigation can ensue. I believe it is likely that this litigation will mostly be fruitless. The ACA decision is likely to be a one-off based on the size of the Medicaid program as a proportion of state budgets, 20% on average, the threat of existing Medicaid programs in states that did not expand, that the program entirely would be cut off, and the court's perception of the expansion as a radical change in the nature of Medicaid, a change in kind rather than in degree. Nonetheless, we will probably only know after years of litigation how radical a change in the law this case has wrought, and in the meantime, Congress may be more reticent to change existing spending clause programs. Finally, the Chief Justice's interpretation of the necessary and proper clause makes me quite nervous. Much seems to turn in the Chief Justice's mind on whether legislation is not only necessary but also proper. The Chief Justice says little about how the courts are to determine whether Congress's exercise of its powers are proper or not. And as Justice Ginsburg notes in dissent, the court seems to be opening up another "I'll know it when I see it" kind of test. Given the activist nature of our current Supreme Court, I find the fact that it has now assumed the right to determine whether legislation duly adopted by Congress is proper or not to be quite disturbing. In any event, as one who believes that the Affordable Care Act, however flawed, and I could spend the rest of the day up here talking about flaws in the statute, that it is the only vehicle we will have anytime soon to address real and serious problems in our healthcare system, I am relieved that the court left it largely intact. I do worry, however, about the extent to which the court has constrained the ability of Congress to address national, social, and economic problems in the future. Thank you.
Thank you, Professor Jost. Our next speaker is the Honorable Christopher DeMuth, a distinguished fellow at the Hudson Institute in Washington, D.C. He was president of the American Enterprise Institute for Public Policy Research from 1986 until 2008, and the D.C. Searle Senior Fellow at AEI from 2008 through 2011. Many of his articles, lectures, and talks are posted on his website, christopherdemuth.com. You see a trend here, also a 1973 graduate of University of Chicago Law School. He served as staff assistant to President Richard M. Nixon in 1969-1970, working first for Daniel P. Moynihan, who was then assistant to the President for Urban Affairs on urban policy matters, and then as chairman of the White House Task Force on Environmental Policy. Following law school, Mr. DeMuth practiced regulatory, antitrust, and general corporate law with Sidley and Austin in Chicago from 1973 until 1976, and he was the Associate General Counsel of Consolidated Rail Corporation in Philadelphia. From 1977 through 1981, Mr. DeMuth was lecturer in public policy at Harvard's Kennedy School of Government and director of the Harvard Faculty Project on Regulation. There he taught courses on law, economics, and regulatory policy, and conducted and sponsored research on health, safety, and environmental and economic regulation. Please welcome Mr. DeMuth.
Thank you, Judge Hardiman. Thank you very much. Pardon me. There have been 4 pronounced trends in the administrative state in recent decades. 3 of them, I'll get to the 4th in a few minutes, are, first, the transfer of lawmaking power from the Congress to the executive branch. Second, the further transfer of lawmaking power within the executive branch from rulemaking, adjudication, and enforcement to unadorned administration, management, various informal measures that are beyond the reach of the courts. And third, the forging of federal-state administrative relations and alliances that suppress interstate policy competition and state-federal policy competition in ways that, given the current state of constitutional doctrine, are largely impervious to judicial review. The Supreme Court's decision in NFIB versus Sebelius, as compared to the approach in the joint dissent, which would be to throw out the whole kit and caboodle, will be to continue this trend because the Affordable Care Act, Obamacare, embraces these 3 tendencies to a very dramatic degree. I want to give 2 examples for these sweeping propositions. The first is the Independent Payment Advisory Board, IPAB, apparently the only I acronym that Apple has not trademarked. This group will, in effect, set reimbursement rates for thousands of Medicare services, both directly and through the construction of categories which will have single reimbursement provisions for supposedly like services, but will in fact involve services featuring very different costs of supply and very different levels of effectiveness in treating medical conditions. This sounds like a routine matter of administration. Congress could not decide on the thousands and thousands of reimbursement rates, and the statute explicitly puts it out of bounds for judicial review and even seems to put it out of bounds for congressional revision. Yet, in fact, as everyone inside these programs knows, the reimbursement rates for Medicare are de facto price controls because they are combined with the statutory ban on balanced billing, meaning that doctors, hospitals, others can bill patients for only a set percentage of the reimbursement rate. And they also tend to get swept up into the provisions of private health insurance contracts. So these decisions with immense economic consequence both to suppliers and consumers that are going to have tremendous cross-subsidies in them, that are going to have big effects on innovation, are, absent somebody's coming up with a new administrative law theory or constitutional theory, going to proceed simply through unreviewable management. The second is the question of HHS's, the Department of HHS's definition of essential health services. These are services which within broad categories established by the statute will be the services that will be covered by the private individual policies provided through state exchanges, and which will invariably get swept up into employer-provided contracts as well. Essential health services made a cameo appearance in the NFIB case because the calculation of what is covered has an effect of setting the cap on what the tax for not having insurance will be. These are matters of extreme sensitivity, what is insured and what is not, as exemplified by the enormous national controversy last year about whether universities should be required to provide free birth control pills and devices to their students. But it has been delegated to the executive branch. It is to some degree certainly reviewable, but HHS has very cleverly delegated this question to a significant degree to the states. There will be some baseline coverage established by statute, but other than that, this will be defined by the states, which have long been in the business of defining essential services through mandates of various forms. They vary greatly by state. Those of you who are in Washington State are privileged to have your private contracts cover herbal therapies. Here in Washington, we haven't gotten, we're not that enlightened, we haven't gotten there yet. There will be an enormous amount of variation, but my point for present purposes is that here we have an example of the federal administrative state embracing political decisions made at the state level that are very, very powerfully governed by provider special interests. The fourth trend that I promised to get to is the delegation not just of policy-making power, but of outright taxing power, explicit and increasingly explicit from Congress to the executive branch. This is a particularly striking trend because the Constitution appears to take great care in saying that taxing is a legislative function, not an executive function, and even saying that it belongs in the first instance to the People's Chamber, the House. Here, the court's decision compared to a world where there had been no challenge or where Justice Ginsburg and her colleagues had prevailed and the statute would have been held upheld across the boards, is going to fortify the trend of delegating tax power to the administrative state. This is because the essence of the court's decision is that when it comes to forcing individuals to do things they don't want to do, and when it comes to forcing states to do things that they don't want to do, Congress may impose sanctions that are mild and proportionate, but may not impose sanctions that are strong and disproportionate enough to be effective. But the administrative state has its own means of getting its way, and therefore these forms of implicit and I think increasingly explicit taxation are going to become increasingly the work of the executive branch. The Chief's opinion on the spending clause illustrates that taxing and regulating are broadly substitutable. This is an old story, and I will give you two examples. First, many regulatory agencies routinely grant or deny permission to do things of immense value. Market a new drug, build a power plant of some form, use the electromagnetic spectrum for one purpose or another. And it has long been known by those on the inside that there are implicit conditions of good future behavior, continuing good behavior, that are considered a part of these grants, good behavior that is often very costly for the licensees. But it has increasingly become explicit taxation. The big year here was 1974. Since LBJ had been majority leader, the power of the committee chairman had been weakened, and then in the 1974 Budget and Impoundment Act, it essentially sealed the doom of the four individuals in the Congress who were in charge of enforcing this aspect of the separation of powers. The Appropriations Chairman in both houses, the Chairman of Ways and Means in the House, and the Chairman of the Finance Committee in the Senate. Since then, and increasingly over time, there has been no discipline in the budget process in the House and Senate. We've seen a dramatic profusion of this trend in recent years, and the Congress has been increasingly interested in facing constraints between the demands that are placed on it and its ability to respond to those demands, to delegate taxing power to the executive branch. In that same year, there's a fascinating, mysterious little Supreme Court case, National Cable Television Association versus the United States. There was an old statute going back to the early 50s that said that executive agencies should, to the extent possible, raise revenues from fees that are charged to people that are receiving benefits from what they do. The original conception was concerned mainly with entrance fees at Yellowstone, things like that. But the statute did mention licenses, and it had some very broad language to direct the agencies how they should set their fees. They should set them according to the value to the recipient, public policies or other interests served, and other pertinent facts. That language was very troubling to the court, which was split. The majority, writing through Justice Douglas, said that this was, he obviously had serious constitutional concerns. The FCC had been raising and raising its fees under the pressures of increased Congress's wanting the FCC to raise its own money rather than having to tax it themselves. And it was applying it not to cable television providers who had to stay in the good graces of the FCC but didn't have any licenses. They were not using the wireless spectrum. And Douglas was clearly concerned that if they could apply fees to anybody based upon public policy considerations, that would raise serious constitutional issues. He approved, Douglas and the court approved what the FCC was doing, but it essentially said you can take into account value to the recipient, but we're going to just tell you to ignore, as raising constitutional flags, this idea of considering public policy. Justice Marshall was the lone dissenter. His views were different on the delegation matter, but he would have held these fees as violating the statute because he could not imagine that he was a little behind the times on what was happening in congressional politics. He could not imagine that Congress would actually give the FCC the power, so much discretion to set their fees. That was the beginning of a long trend. The FCC has been utterly free of congressional appropriations for a decade now. Its budget is $340, $50 million. It raises it entirely through license fees. Other agencies, such as the Food and Drug Administration, the Nuclear Regulatory Commission, have a similar, they're not completely free of appropriations, but are increasingly so. My second example is traditional public utility regulation, which has long had very substantial elements of public finance, especially in the construction of rate programs where business users and urban users pay prices high above costs of service. Rural users, residential users of telephones, electricity, and so forth pay rates that are way below the marginal costs of serving them. So this has been an implicit form of taxation that goes back about a century. In 1996, by that year, the telephone monopoly had been eroded as a result of the AT&T divestiture. Entry, which had focused on routes and services where AT&T's prices were high above cost. The old method of taxing some customers and spending the money on other customers through the rate structure was at an end. You might have thought that Congress would have said, well, now we have competition, we don't have to worry about it anymore. But what they did instead was to substitute implicit taxation for implicit taxation, direct taxation. The FCC was empowered to impose a explicit outright tax. It calculates it every month, depending on its estimate of how much it wants to spend for various purposes, rural health care clinics, internet connections to people with low income, other worthy causes. The tax is now over 17%. It's a huge tax on the covered interstate, some international telecommunication services. It raises $8 to $9 billion a year. It was once challenged on constitutional grounds. The challenge was brushed off in a few sentences by the Fifth Circuit. It obviously saw that this was a natural progression from the old form of implicit taxation to the new form of explicit taxation. One more example, I'll get back to Obamacare and then conclude. The various forms of delegation of taxing power have now gone to considerable extremes. The Public Company Oversight Accounting Board, established by Sarbanes-Oxley, it's a 501c3 established in Washington, D.C. It's like the Federalist Society. It's like Hudson Institute, except Congress gave it the power to tax. It figures out what it wants its budget to be for the year, and it divvies it up, divvies it up among most publicly traded corporations, weighted by their calculation of their asset value, and sends them a bill. And it has no relationship to any form of appropriations. It is essentially an autonomous special purpose government with its own taxing authority. Now, several of these authorities, for example, the FCC's, if you don't pay what is called a contribution, it can refer the matter to the Department of Justice. It doesn't have to refer it to the Department of Justice. It has ongoing relationships with all the people who have to pay the taxes. Sometimes they don't pay, but then they get an assessment notice, and they will be denied, for example, licenses in the future or other things that they need from the Commission. A particular favorite of mine is that in the Public Company Accounting Board statute. If a company doesn't pay that contribution, no accounting firm may certify the accuracy of its financial records for any regulatory purpose. Collecting that tax is not a problem. The tax in the Affordable Care statute is probably ineffective beyond anything that the court recognized in its opinion. Not only is it very low, but there's very little enforcement mechanism, and it was part of the condition of the courts approving it under the spending clause that it not be subject to criminal enforcement. But if you work through the statute, essentially the only way this can be collected is if you failed to report that you didn't have health insurance and you over-withheld during the year to a degree that the IRS cannot refund your overpayment. That's the only mechanism. A very, very weak mechanism indeed. There was some thought that what Congress had in mind was to get the apparatus in place and then come back with more sanctions and higher taxes for not having insurance. Whether it would have wanted to do that, this was controversial. Whether it would have been able to, I don't know. But the court's opinion has essentially taken that off the table. And here, I think we have another step in the delegation of taxing power to the executive. A lot of people think that without an effective penalty or tax on uninsurance, the statutes having put in place policies for guaranteed issuance, a ban on considering pre-existing conditions, and community rating will lead lots of people to go without insurance. And the general idea in people's minds is when you're in good health, but then when you have an accident or your doctor tells you you've got brain cancer, you just pull out your BlackBerry, you call up Aetna, and you sign up that day at a community rated rate. It's not going to work out that way. Private insurance companies have lots of means of policing these boundaries, and the Department of HHS and the states are going to have many, many means. For example, you can say that you do have community rating and guaranteed issuance, but you only have it for 1 month a year. We're familiar with this, many of us in employer-provided plans. That takes out a lot of the gaming of the system. There are ways to make the exercise of one's right to community-rated, guaranteed issue insurance for those who have not purchased insurance in the past to be delayed, to be made costly, to be made difficult in all sorts of ways through direct administration, which will have the effect of supplying the defect of the lack of explicit legislative penalties. I agree with Professor Jost. This is beyond this case and the case of vegetables. It's hard to imagine how much difference it makes. But in this one particular area, I think we see another step toward the delegation of taxing power to the executive branch. The administrative state that we have today has been built exactly on a multitude of such small incremental steps in the past. Thank you.
Thank you, Mr. DeMuth. Our final, last but not least, certainly, speaker is Judge Brett Kavanaugh of the Court of Appeals for the D.C. Circuit. Judge Kavanaugh was appointed to that court on May 30, 2006, a 1990 graduate of Yale Law School. Judge Kavanaugh served as a law clerk to my colleague, Judge Walter Stapleton, and then for Judge Kaczynski on the Ninth Circuit. In 1992 to 1993, Judge Kavanaugh worked as an attorney in the Solicitor General's office, and during the October term, 1993, he served as a law clerk to Justice Anthony M. Kennedy. From 1994 to 1997, and for a period in 1998, Judge Kavanaugh was associate counsel in the Office of Independent Counsel Kenneth Starr. Judge Kavanaugh was a partner at Kirkland & Ellis in Washington, D.C. from 1997 to 1998, and again from 1999 to 2001. From 2001 to 2003, Judge Kavanaugh served as associate counsel and then as senior associate counsel to the President, George W. Bush. From July 2003 until his appointment to the court in 2006, he was assistant to the President and staff secretary to President Bush. Since joining the court, Judge Kavanaugh has taught law at Yale, Georgetown, and Harvard, where he has been named the Samuel Williston Lecturer on Law at Harvard Law School during the last 4 winter terms. Please welcome Judge Kavanaugh.
Good morning, and thanks to Judge Hardiman for the introduction and for being here. People said to me, why do you agree to do the Saturday morning Federalist Society panel? And I said, I like the Saturday morning Federalist Society panel. It's you weed out the glad-handers and the hangers-on. This is the hardcore right here, Saturday morning. You all are interested in law, and we'll give you a little more this morning. So thank you for being here on a Saturday morning. I'm pleased to be here, and I'm pleased to be with the members of this panel and with Judge Hardiman in particular. He mentioned that I worked in the White House counsel's office for a number of years, worked 5.5 years in the White House for President Bush, and one of the things I worked on, particularly in the beginning few years in the White House, was judicial selection. And it's great to be at this conference and to see some of the people that President Bush appointed in the early years of his presidency, who have made such a distinguished mark on the judiciary and have done so much to advance the development of law in our society. Judge Hardiman, Judge Bea, Judge Sykes, Judge Pryor, Judge Timkovich, Judge Gorsuch, Judge Elrod are all here and are all, I think, great examples of judges who are very smart, extremely principled, and good people who are making an influence every day in the judiciary. And I'm proud to be associated with those members of the bench, including Judge Hardiman here today. So thank him for being here. We're going to talk and have been talking a little bit about NFIB, of course. What are the lessons of NFIB? And I want to take a step back and try to give, from my perspective, a lower court judge, someone who teaches separation of powers law and constitutional law, what are some big picture things I think come out of NFIB? Obviously, there's huge policy debate. Some of that we've heard today. There were huge political implications. Not going to talk about that here today to the decision. But in terms of the longer-term structure, the longer-term edifice the longer-term Constitution that all of us in this room care about so much, what are some of the things we can take away from NFIB and learn and use to analyze future and other cases? So I think there are three I'm going to focus on briefly this morning. First, NFIB, again, is another example of many where the court, the Supreme Court of the United States, will enforce the structural limits of the Constitution. Second, that the power to regulate commerce is not the power to force people to enter commerce. And third, that the constitutional avoidance doctrine is a tool, a somewhat formless tool that can be applied in ways that people don't like sometimes, but it's a tool that the courts use at times as a brushback to Congress to force Congress to speak more clearly when Congress wants to enact legislation that will get close to or at the constitutional line. So let me talk about the first. The court will enforce the structure of the Constitution. This is critically important. This is the Commerce Clause part of the court's holding. 5 justices conclude that the Commerce Clause does not support the individual mandate portion of the Affordable Care Act. And when I read this part of the opinion, and actually when I thought about the case beforehand, I really thought of the Commerce Clause issue in the same way as the Free Enterprise Fund case from a few years earlier. Another case, not a federalism case, but a separation of powers case, where the court was enforcing a structural limit on the Constitution. In that case, as you'll recall, Congress had created an entity, the Public Company Accounting Oversight Board, a new independent agency. Okay, there are independent agencies out there. We know that. Humphrey's executor blessed them in 1935. But this was a new kind of independent agency. It wasn't appointed by the president subject to Senate confirmation. It was an independent agency appointed and removable for cause only by another independent agency, the SEC. Double for cause protection, a new kind of governmental structure. And the Supreme Court confronted the constitutionality of that entity under Article 2. And if you look at the court's decision in Free Enterprise, a structural case, a case where Congress has taken a step to create a new entity to deal with new problems, what does the court say? The court says no. And how does the court get there? Well, first of all, the court relies on the text, the precise words of the Constitution. The first 15 words of Article 2, the executive power shall be vested in a president of the United States of America, not in the independent agencies. Article 2 doesn't say Congress can create independent agencies as Congress sees fit to regulate in the public interest. No, it says the executive power shall be vested in a president of the United States of America. And Chief Justice Roberts' opinion for the court really focuses on the precise, actual words of the text of the Constitution as the starting point for how to analyze this structural case. And then what does the opinion say? Then the opinion says, and this is a novel structure. This double for cause thing is a novel and unprecedented structure. This is something we haven't seen before. We've seen independent agencies, the court says, but we haven't seen this kind of thing and this kind of unprecedented structure. And the court says perhaps the most telling indication of the constitutional problems with this new board is the lack of any precedent for it. Now, there was precedent out there, of course, allowing independent agencies, Humphrey's executor in 1935, and the theory of the government was, well, why not just extend Humphrey's executor? If you've allowed some intrusion on Article 2, why not just open the door? Or hasn't Humphrey's executor already opened the door to any kind of independent agency as Congress sees fit? Wouldn't it really be just in keeping with Humphrey's executor? And the court says no. Humphrey's executor did allow some intrusion on Article 2 as the court seemed to have read it in Myers and as the court in Free Enterprise would seem to read Article 2. But we're not going to go beyond Humphrey's executor. We're not going to extend Humphrey's executor. It allowed one for cause provision. We're not going to go to the double for cause provision, this new kind of independent agency. And the court considered the implications. If we allow this, What's to prevent an entity that's 5 levels of for-cause removal from the president? As the Chief Justice said in Free Enterprise, this was too much. Congress cannot reduce the president to a cajoler-in-chief. The president, the buck stops with the president. And the president, Humphreys carves out an exception, but the implications of allowing the board and free enterprise to be upheld would allow Congress to really fragment executive power in a much more significant way that would be inconsistent with the text of the Constitution. The court said no. Now look at NFIB, the Commerce Clause part of the Chief's opinion. In fact, if you want something interesting to do, if you go read Free Enterprise, the Chief's opinion, and go read the Commerce Clause part of NFIB, there are extraordinary similarities in the two opinions, in my view. First, on the Commerce Clause, the Chief Justice starts where? With the text, the precise words of the Constitution. Regulate commerce. Focuses in on regulate commerce. Does that give you the power, give Congress the power to force people to engage in commerce, to force people to purchase goods and services? And the Chief goes through the ordinary understanding of regulate today and back at the time the Constitution was written and said, no, regulate means regulate commerce that's already existing, not to force people into purchases. The precise words of the Constitution, again, so important to the Chief Justice. Then where does he go? The novelty, just like in Free Enterprise, the novelty of this, the mandatory purchase requirement. One of the things when this case first came up, when I first heard about it, I think what a lot of people, gee, I wonder if has Congress done this before? They probably have done this before. There's so many statutes out there. And then I think a turning point in the litigation, a turning point in public thought about this whole issue was, actually, Congress has never done this before. This is unprecedented. Congress has never used its Commerce Clause power to force people to purchase goods or services. It is unprecedented in our 222 years. That was a huge point. It was a huge point for the Chief in Free Enterprise Fund on the double for cause, huge point for the Chief, for the court, and I think for the whole debate on this issue in NFIB. The novelty and unprecedented nature of this, and if you look at the Chief's opinion, he quotes from Free Enterprise Fund about perhaps the most telling indicator of the constitutional problem here is the lack of any precedent for this kind of congressional action. Now, what about precedent? There's Wickard. So Wickard's like Humphrey's executor in Free Enterprise. Wickard's out there, a very expansive notion of the Commerce Clause. And the Chief accepts that, and the court accepts that, but no further. The Chief, just because commerce has been stretched, just like in Free Enterprise, just because incursions or intrusions on Article 2 have been stretched, okay, we're not going to necessarily go back in this case, but we're also not going to stretch it further. We're not going to go further. The Chief draws the line and says, this is fundamentally different from the kind of commerce that was at issue in Wickard. This is forcing people to purchase goods and services. That's not what Wickard was about. We are not stretching Wickard to cover this new kind of congressional action. And then the implications. So the implications in Free Enterprise were erosion of Article 2, fragmenting executive power, all sorts of congressional takeover, essentially, of the executive branch. Here, it's the erosion of federalism limits in NFIB. The implication of if the court can engage in these, Congress can engage in these kinds of mandatory purchase statutes, what else could they require people to purchase? As the Chief ultimately says, this is not the country the framers envisioned. This is not the Constitution the framers envisioned. Setting down a tough, hard line on what Congress can do, enforcing the structural limits. So I think that's an extremely important aspect of NFIB, that the court, like in Free Enterprise Fund, will enforce the structural limits of the Constitution. It's not just whatever Congress says goes with respect to structural limits. And we hear Neil Katyal, who's a brilliant lawyer and was Solicitor General, and he has challenged, I think, this idea that the court should play a role in enforcing the structural limits. Has said that's inconsistent with some notions of judicial restraint. And I think that's quite incorrect, and that needs to be, that assertion needs to be challenged. And the idea that the court has a role in these kinds of structural cases needs to be defended. And we believe in Marbury versus Madison. It starts with that, right? We believe that courts have a role in enforcing separation of powers and federalism limits on the Constitution. And it's not a new thing for judges who believe in the structural principles of the Constitution to believe that the court has a role in enforcing those, whether it's Chadha or the Line Item Veto Act case or free enterprise or now NFIB. And it goes back throughout the court's history. Judicial restraint, of course, is often articulated in terms of restraint in creating, for courts creating new unenumerated rights under the guise of substantive due process. That's where judicial restraint is often articulated. But judicial restraint does not mean, in a case involving the structural limits of the Constitution or a case involving the First Amendment or Second Amendment or Fourth Amendment or Sixth Amendment, judicial restraint does not mean judicial abdication. Judicial restraint does not mean that courts give a pass to what's happened. Courts are supposed to exercise their own independent judgment in enforcing those limits, in enforcing those constitutional protections. And I think it's important for people who believe in the structural Constitution and believe that courts have a role in doing that to counter the notion that somehow that's inconsistent with a principle of judicial restraint. The second big point from NFIB, the power to regulate commerce does not equal the power to force commerce. 5 justices so conclude, the Chief Justice and the 4 dissenters. And that is just, to me, a major principle of constitutional law. I know everything gets lost in the precise holding and the politics and the policy, but just thinking kind of longer-term stream of constitutional decision-making, that this was a potential inflection point. The power to regulate commerce, does that give Congress the power to force mandatory purchases of goods and services? And I respect the idea that this would, that some have articulated that this would just be health care, but something like this, when it's out of the shed, when this tool's out of the shed, it can be used for all sorts of purposes. Mandatory retirement accounts, mandatory college savings accounts, mandatory housing accounts, mandatory food accounts, mandatory disability insurance, mandatory auto insurance at the federal level. This kind of thing, if it had been approved under the Commerce Clause, would have given Congress a big new tool. And I think this is an important structural principle that the court reinforced in NFIB, 5 justices reinforced in NFIB, namely the power to regulate commerce does not equal the power to force purchases of goods and services. And the third, as I mentioned, constitutional avoidance. Constitutional avoidance is a tool the court often uses as a brushback, essentially, to Congress to say, we're not going to interpret the statute to go where it may, by its plain terms, reasonably be read to go, because that would entrench upon constitutional limits. And so we're going to interpret the statute more narrowly. We're going to interpret the statute differently. And in NFIB, the court, the chief, did this in construing. He said the mandate would present constitutional problems for the reasons we've discussed, but if it's construed as a tax incentive provision, that constitutional problem would go away. There's huge debate about whether this was a proper application of the constitutional avoidance doctrine or not. I'm not going to get into that debate other than to say the chief and the court, therefore, construed it to be a tax incentive. And as a tax incentive, it is quite common in the tax code for there to be tax incentives that encourage behavior or discourage behavior, but don't mandate certain behavior backed by sanctions, whether it's charitable deductions or cigarette smoking or gambling or the home mortgage deduction or solar panels. There are lots of examples in the tax code, and the chief construed this to be yet another tax incentive, and as such, within the scope of the taxing power. The bigger principle there, the constitutional avoidance doctrine, is a doctrine that courts will rely on. And as litigants and as judges, all of us need to be aware about that doctrine and to pay attention to the ability of that doctrine to essentially defuse an otherwise hot constitutional issue. The court has seen fit to do that on many occasions in the past, and of course the chief decided again to do so in NFIB. So I'll sit down with that. The one overarching point that I want to stress again, though, is what I see as the longer-term picture of NFIB. The Supreme Court has an important, robust role in enforcing and protecting the structural limits of the Constitution. Thank you.
Thank you, Judge Kavanaugh. Obviously, I want to make sure there's time for questions you may have, but before we do that, I have a couple questions for our panelists, but quickly, I want to give our panelists the opportunity to very briefly respond to anything that they heard from their fellow panelists. So, Mr. Cass?
I would just jump in on two quick points. First of all, I know Tim was worried about the degree to which this would constrain beneficial action by the federal government to solve national social and economic problems. And I think it's important to distinguish a view of that concern from a view that is concerned about giving the national government a free and open charter to solve problems, as opposed to having a charter that says, here are certain powers you have, you may deploy them as you see fit, but your powers are limited, you only have certain activities you can regulate, and you have only certain mechanisms for regulating them. And I think certainly the view of the commerce power taken by 5 of the justices was that we have a constitution that limits the activities and actions the government can take. It doesn't simply say, do what you want to solve important problems. I think that's an important distinction.
All right. Professor Jost, you want to respond?
Yeah, I mean, I think that the Congress has powers under the Constitution, in particular the Commerce Clause and the power to tax and spend, because there are problems that are national problems that the states are not capable of solving. And I think that the health care is the prime example of that. The states have had decades to solve the problems of the uninsured, and they have proved completely incapable of doing it. The state that's come the closest, Massachusetts, did it with a massive infusion of federal money. I think that the Constitution does, of course, limit the powers of Congress, but it does give the Congress the powers to address this problem. I wanted to ask a question, could I?
Sure, absolutely.
Yeah. Listening to Judge Kavanaugh, I frankly like the D.C. Circuit's decision in Seven Sky better than I like the Supreme Court's decision, but I found Judge Kavanaugh's dissent in that case very interesting, and I read you as being somewhat open to the power to Congress having the power to compel private purchases as a tool that Congress might want to have for the further privatization of public programs. Did I misread you?
In my opinion, in Seven Sky, I articulated that the court shouldn't decide the case yet because the Anti-Injunction Act was a jurisdictional bar on the case, and then I reached that conclusion based on the text of the Anti-Injunction Act, which I do not commend to you.
It was a marvelous opinion.
Yeah, well, it's a painful opinion. But at the end, I added on top of the text of the the Anti-Injunction Act, there were some prudential reasons to avoid jumping into this too soon, and one of those was to avoid resolving a Commerce Clause issue that was quite heated and difficult and that had big implications either way. And I talked about the big implications of going one way because that would greenlight this major expansion of congressional power, and I talked about the implications of the court going the other way because it would essentially hamper Congress from using certain kinds of targeted private accounts, and that this was a big issue that we shouldn't jump into prematurely if we didn't have to. I think my opinion did not take a position on that because I was just trying to say there were was trying to say there were big issues involved, and if you don't have a jurisdiction, if you have a jurisdictional bar, don't strain to avoid the jurisdictional bar when these big issues with big implications are presented. So that's how I was setting it up.
All right. I think my questions are important, but I'm going to assume that they're less important than the line of folks standing there. So please keep it brief and fire away to the panel.
Thank you, Judge. As a 1978 graduate of the University of Chicago Law School with an undergraduate degree from Yale, I'd like first to salute the eminence of this panel and the people who put it together.
Well, as a graduate of Georgetown and Notre Dame, you can go to the back of the line.
Touche. So, picking up on Dean Cass's example of humor to make a point, it's been said in the military that the term MRE, or meals ready to eat, is really 3 lies in one. They're not meals, they're not ready, and you can't eat them. It seems to me the same could be said of the ACA. It's not affordable. It has less to do with health care than it does about the continuing intrusion of the Leviathan state into people's individual decisions. So my question is for Professor Jost, can you defend the third letter of Affordable Care Act, constitutional principles aside? How does Professor Jost respond to the critics who say that the act is politically illegitimate and that it was rammed through without a single vote to spare and a lame duck Congress, some of whose members had already been voted out of office and others of whom would be shortly thereafter in the election of 2010?
Well, once again, I would just say what I started to say, which is that this is an act that was intended to be bipartisan. It was built on principles that came out of Republican bills. It was not creating a massive new public program. It was trying to make our private health insurance work. The individual mandate, for example, was found in legislation sponsored by 11 sitting Republican senators at that point. Newt Gingrich had supported it. Governor Romney, of course, supported it in Massachusetts. It was basically a law that was passed to make the private system work. In the Senate Finance Committee, the Senate Health, Education, and Labor Committee, there were, I believe, 161 amendments adopted, proposed by Republican senators. Senator Grassley wrote large parts of the bill. It was a genuine attempt to come up with a bipartisan solution. In August of 2009, as we remember, the Tea Party took on this bill as a cause célèbre, and the senators who were actively involved in negotiation with the Democratic leadership, Republican senators, decided that the Republican Party had more to gain from opposing this bill than from voting for it. And so in the fall of 2009, then became a bill that was solely supported by Democrats. One Republican House member voted for it in the House, and then it went through from there. And of course, then the Democrats lost their supermajority in the Senate. But I think that the legitimacy of this bill is demonstrated by the past election, which saw the president getting a strong majority, as majorities go nowadays, for re-election. Saw Democratic senators actually gaining seats in the Senate, and I believe that Democratic House members got more total votes than Republican House members, although the country is so badly gerrymandered now, they have fewer seats than the Republicans have. I think the American people don't understand this legislation. They've been badly misinformed as to what's in it. But the exit polls showed that more support it than oppose it, and that the number who want to repeal it has dropped dramatically. So I think that it is politically legitimate. Now, once again, it's not the way I would have done it. There are very serious problems with the legislation that we didn't discuss today. I'm a consumer representative to the National Association of Insurance Commissioners and spend a couple of hours every week talking with insurance commissioners about how they're possibly going to make this bill work. But I do believe that it is politically legitimate.
Dean Cass, you wanted to say something?
I believe that the legitimacy of the bill, in answer to David's question, legitimacy of the bill really shouldn't be judged by who drafted it, who voted for it, whether Republicans or Democrats embrace the ideas, or how many people support it now. I think the question of legitimacy is one that turns on its consistency with the constitutional structure and with the rules we have in the Constitution that limit what Congress can do. So from my standpoint, that question is independent of popular support or how it was drafted.
So a distinction between political legitimacy and judicial or constitutional legitimacy. Is that your?
I mean, I certainly would view the only serious question of legitimacy to be one that has to do with its consistency with the Constitution, not with its popularity or the sort of support it got along the way.
Okay. Next question.
Thank you, Judge. Judge Kavanaugh mentioned the court's concerns about double insulation of entities from executive supervision, and indeed the problem of general lack of accountability. Some critics have, in analyzing the Consumer Financial Protection Board, have pointed out that, in effect, it receives funds from the Federal Reserve Board, which is outside the appropriations process, but it is not even supervised by the Federal Reserve Board. And in a number of other respects, it appears to be largely immune. In fact, it cannot, according to the statute, be called, its leadership can't be called before the appropriations committees. So I obviously won't ask the judge, but does anybody else want to comment on, given the judge's insights on double insulation principle, and does anyone suggest that might have implications for the constitutionality of that entity as litigation proceeds?
I'm going to take
The judge will comment. Oh, I was going to say, as your counsel, I advise you to sit back. Anybody want to take that on?
I'll say I'm much more disturbed about the constitutionality. I'm much more disturbed about the creation of autonomous governments with their own taxing power than the courts have been. I think that this new agency is a little bit different than the examples that I gave because it's not actually a tax, it's a profit. The Federal Reserve banks are extraordinarily profitable. The genesis of this idea of having these banks that have an important public function in monetary policy is one thing, but the Federal Reserve Board has been given increasing regulatory power over the private economy. Many statutes in recent years, other than Dodd-Frank, there's the credit card legislation and so forth. And it seems to me that when we have this immensely profitable bank that is our national bank, that we're giving public policy powers to, I think that raises a very different order of constitutional concerns. And when you create this insulated ward, sort of a ward agency, it gets all its money out of the Federal Reserve profits, and its only job is to regulate private entities, it seems to me we have something that is highly problematical as a constitutional matter.
Keep paying attention, Chris, because this question is for you. I really liked what you said about how the administrative agencies have ways of dealing with those who seek to game the system. Yes, looking at the statute on a practical level. And the only kind of legitimacy I'm concerned about right now is how the hell this thing is going to work when people actually see how much it costs and what's going on and how the healthcare system is developing. So on that basis, I'd like you to just comment on two parts of the healthcare system. First, in the District of Columbia, small businesses with less than fewer employees are now mandated to buy insurance through the exchanges. They've prohibited the private market for insurance. Now, I'm in the uncomfortable position in my business of we don't know whether to be outraged about this or not. Is there going to be any difference? Supposedly these exchanges are competitive. That's number one. And number two is, do you see that iPad or whatever it is,
iPad.
yeah, eventually evolving into the kind of system that controls end-of-life care in a similar way to what they have in Europe? One assumes that it would have to if we're going to deal with healthcare costs, and that would be an interesting new extension of administrative power also, I would think.
I think that many aspects of the statute will prove to be unworkable and a disappointment to those who voted for it and feel enthusiastic about it. Because many compromises were made that I think that the administrative apparatus of the government, as powerful as it is, can't really solve. We will see that the community rating and guaranteed issuance provisions are much less than a lot of people think they're going to be. The subsidies for the combination of the incentives for private employers to drop insurance for large numbers of employees, and the actually rather meager subsidies that are going to be there for exchange purchased individual insurance it's going to cause a lot of unhappiness. And the natural incentive, and I think what was in the mind of the people that wrote the bill, is get the apparatus in place, increase the subsidies, and clearly the evolution is toward either a single payer or the same thing, a small number of nationally approved insurance companies operating under plenary public utility controls. That's what they have in mind, and whether with the amount of subsidies there, you can accomplish what you're trying to do without turning the system into a post office system or the railroads such as we had in the 1960s and 1970s. I mean, crummy to a degree that there's enough public reaction. I think it remains to be seen. It's going to be very hard when the expectations are disappointed and we are in a continuing debt crisis where it's going to be more and more difficult to just say, well, the federal government will put another $1 trillion into the kitty to relax these problems. I forget what your second question was, but
I'm going to ask Professor Jost to respond, and in the context of your response, would you tell us whether you agree with what was just said regarding this evolution toward a single payer system, and if so, do you envision it the way that Mr. DeMuth explained it?
Well, let me first address the IPAB. The Independent Payment Advisory Board was created because of frustration with the inability of Congress to get the costs of the Medicare program under control, because it is always easier for Congress to scratch the itch of some special interest that wants more money than to think about what the program costs as a whole. And so basically what the statute says is if the cost of Medicare continues to grow in an uncontrolled way, then somebody has to step up to the plate and manage it. And so this Independent Payment Advisory Board will be appointed, and if costs are projected to grow above a certain level 2 years out, then they're going to have to come up with a proposal. They'll make that proposal to Congress. Congress can change it if it wants to, but if Congress can't figure out what to do, then the proposal will go into effect. The statute explicitly prohibits them from rationing care, explicitly prohibits them from changing benefits. Basically, the only tool they have to work with is provider payments. Fortunately, the cost of health care in the United States has been growing at historic low levels for the last 2 years, 3 years. Levels is lower than what we've seen since the Eisenhower administration. And the CBO projects that the IPAB target is not going to be hit again for a number of years. Also, other cost controls in the bill are contributing to that. Frankly, I don't think the IPAB's ever going to happen. It's a 15-member board that has to be cleared by Congress. It has to be people appointed for 6 years who agree to work for $150,000 a year with absolutely no outside income. And I wouldn't take that job, and I don't think anyone in this room would. I don't think it's going to happen, but fortunately Medicare costs are at this point growing at a lower rate than they have been, and hopefully we can keep them there. With respect to the future of the Affordable Care Act, and I don't think it was intended to evolve into a single-payer system. Congress couldn't even agree on putting out a public option, which many people wanted, as one of the options that people could pick. On the other hand, I think there are a lot of problems with our private health care system, and we'll see whether it will continue to work for us. But I don't think that was the intention of the people who wrote the bill. Their genuine intention was to make our private health care system work, because it's not working very well right now. And whether that will happen or not remains to be seen.
Quickly.
Kai Alberg, Port Angeles, Washington. As a private plaintiff in the Obamacare lawsuit and somebody who does not intend to obtain health care or pay the tax, I want to thank Mr. DeMuth for confirming the toothlessness of the enforcement mechanism. My question, though, is not as to enforcement, but as to the amount of tax an agency can constitutionally extract without the congressional mechanism of originating a bill in the House and presenting it to the President. Let's assume the EPA, Obama not being able to get a carbon tax through the House, enacts a carbon tax imposed on electric utilities and petroleum refiners. And let us say that brings in $4 billion a year, or $40 billion, or $400 billion. Is there a limit at some point as to the amount of money that an agency can bring in through a tax that does not originate in Congress? And if so, how would such a limit be determined?
Stay tuned.
Stay tuned is one answer. All right.
In the early days of public utility regulation, there were a series of constitutional decisions that constrained price and rate of return regulation. Essentially, it couldn't be confiscatory. I mean, there are other words that, that the court used. I do not know, and I think there are none, cases involving health, safety, and environmental regulation as opposed to economic regulation, where somebody asserted that the costs of complying with this regulation will put me out of business, to the extent that this is unconstitutional, trying to borrow these older precedents. One can imagine it. Maybe there are some little cases here or there, but it's not a highly developed point of law yet.
Well, presumably such a tax would be passed on to the consumer. In Europe,
yes.
People are routinely paying $7, $8 a gallon for gas, which might be the result here, and that probably would be the result of such a tax.
The argument would be that you have competitors that are not regulated that prevent you from passing it on, so that the costs are passed on to the owners to a degree that is confiscatory according to the standards of these old constitutional cases.
Very quickly.
Yeah. So this is a question probably primarily for Professor Jost. You expressed, I'm sorry, I'm Ilya Soman, George Mason Law School. This is a question primarily, I think, for Professor Jost. You expressed concern about the court taking it upon itself to decide what is or is not proper under the necessary and proper clause. So I wonder if I could probe your view on this a little bit. Is your view that the word proper simply doesn't impose any constraints beyond whatever is imposed by necessary, or is it your view that it does impose some constraints, but those are not ones that the court could enforce? I think either or both of those positions, there are arguments for them, though I don't buy them myself, but either would require overruling several Supreme Court precedents and also going against things that were said by as far back as people like Alexander Hamilton, who explicitly wrote in the Federalist Papers that proper is a separate and enforceable constraint. I wonder, which of those views is yours, or perhaps you have a third view that's different from either. Thank you.
As I said at the outset, I don't teach constitutional law. I'm not a constitutional lawyer, and so I don't think that I have an opinion on that that would be worth very much. What troubled me about this case was that I saw absolutely no limits to, or neither did Justice Ginsburg, to what proper meant, other than that the Chief Justice thought it was improper. Does it mean something independent of necessary? Probably, and I'm not, we can talk more about that later.
All right, very quickly, one last question.
My name is Eric Osborne. I'm with Sidley Austin here in DC. A question for Mr. DeMuth and Professor Jost. I was really taken by your point about the inability of the government to collect the individual tax. And it makes me think of one of my biggest concerns with the ACA, which is how it restricts high deductible health plans I'm a very big advocate of such plans, which I think make market sense. Now, let's say I wanted to buy a high-deductible health plan with a $20,000 deductible. As I understand it, that would not be legal under the ACA. But if what you say about taxation is true, the government couldn't actually tax me for having bought an invalid plan. The problem, as I see it, would be where could I get such a plan? Because in theory, such plans would not be legal. But then the question becomes, as I understand it, states are still the ones who regulate the insurance market. And a state insurance commissioner is the one who could approve whether or not a company could sell such a plan. You have states doing various things to try and sort of push back against the law. Could a state actually, commissioner, basically approve a high-deductible health plan that doesn't follow what the ACA mandates, and individuals buy that plan and then not be taxed, and you effectively get around the act?
A fascinating question. I don't know the answer. Maybe Professor Jost does. But if it's permissible, I think you've got a great business idea.
It is an interesting question. The statute actually is going to, and I think this is one of the surprises in the statute, that people are going to have much higher cost sharing than most people are used to now under the statute. The bronze plan is going to basically be a high deductible plan. A $20,000 deductible probably not going to be covered, but $10,000 deductible will be available to some people. $5,000 deductible will be available to lots of people. Well, in the individual market at least. In terms of whether a state insurance commissioner could approve a policy in the individual and small group market with a $20,000, well, with the $20,000, in the large group market too, with a $20,000 deductible, not a policy that would qualify as minimum essential coverage. There are policies out there that are being sold, that will be sold, that concern me, that don't qualify as minimum essential coverage, that are legal. You'll probably be able to find one, if you don't mind paying the tax.
Standing between you and lunch, I withdraw. Please join me in thanking our distinguished panel.